Okay, so names of companies. When we were discussing the processes which must be gone through before a company is incorporated, among other things, we came across the point that the company must have a proposed name. So now I want to learn more about the names of a company. So Section 21 is one of the novel things which have been added to our company law, because until 2019, some of the things which are provided here were not part of our company law if you go and look at the repeal at 179. So, for example, if we take private company limited by shares, the ending or the suffix is supposed to be limited company. So, Kofi Limited Company or Kofi Ltd, meaning that it is a company limited by shares, it's a private company. Previously, we did not have this qualification. Previously, if you saw limited company, it simply meant a company limited by shares, and there was no indication as to whether it is a private company or it's a public company. However, and now we have had to draw some distinctions. So we say that where you see limited company or LTD at the end of the name, it should right away tell you that it's a private company limited by shares. And then 21(1)(b), public company limited by shares shall be public limited company, PLC. So now if you see PLC at the end of the name, it should right away tell you that you are dealing with a public limited company. A public company, a limited company, limited by shares, of course. Then if you also see LBG, mind you, you are not talking about LGBT, you are talking about LGB. So examination, I don't want to be reading LGBT. LBG, that is company limited by guarantee. Company limited by guarantee. Previously, we did not have any designation for company limited by guarantee. So maybe you just see Center for Human Rights and Advanced Research, SHRALA, or you just see Abantu for Development or something like that. You will not see anything like LBG or limited by guarantee at the end. But now it is a requirement that if it's a company limited by guarantee, you provide the designation LBG. And D, private company unlimited by shares shall be private unlimited company, PRUC. So if you see PRUC, that means that you are dealing with a private company unlimited by shares. Now you see maybe a lot of law firms and other professional groups, they've registered that like that. And we also have public company unlimited by shares, which is supposed to have the designation public unlimited company, PUC. PUC. So if you see PUC, that should tell you away that you are dealing with the public company unlimited by shares. But the point to note is that when it comes to the name of a company, it is the registrar of company who will decide whether the name you intend to adopt for your company, it is acceptable or unacceptable. Unacceptable in the sense that it is misleading or undesirable. But of course, this is an administrative decision which will be made by the registrar. And if you disagree, or if you are aggrieved by it, you can have a remedy by going to court for the court to intervene. But in Ghana, I haven't come across any case in which no, a person or group of people trying to register a company, they suggested a particular name, and then the registrar said no, and they took it up in a court. I haven't come across anything like that, but if you've come across something like that, you can share with us on the class platform so that all of us can read it. Another point to note is that a company shall not be registered with the name of a company that has been dissolved within the preceding 5 years of the intended registration. So that if, let's say that a company was dissolved within the last 5 years, you are not allowed to use the name of that company. If you want to use the name of that company, you have to wait for maybe the 5 years will lapse. Then you enter the 6th year. Then the registrar may permit you. For good reason. You know, names are also associated with the goodwill of the business. And of course, and then the negative reputation is also applicable. Yes, somebody, Frida's hand is up. Frida, you can speak. And then I saw Frida's hand up. Okay, maybe it's a minute. Okay. Now, it is also permissible for the company to change its name. Now, mind you, and these are some of the, company law is not difficult, but company law is technical. When we say it's technical, what it means is that there are certain things which are cast in stone. You cannot do anything about it. You either know it or you don't know it. You cannot guess. So that is why it's technical, but it's not difficult per se. So if you look at section 21.4, for example, that a company may, in writing, change its name by special resolution and with the written approval of the registrar. Now, mind you, we are told that yes, the name can be changed, but how do you get the change? You have to pass a special resolution. You have to pass a special resolution, and last time we look up the meaning of special resolution. So will somebody go to the interpretation session and read what a special resolution is for us? You've explained it already, but I want you to go back. So look at the page 308 of your law and go to special resolution, read it for us. What is it? The interpretation section is the first schedules, but if you go to page 308, it's there. Is anybody reading it?
Page 308A. The office of the registrar of a companies.
No. Okay, you are not using the official version, so your page number is different. If you talk about it, okay. But look at the meaning of special resolution. That is in the interpretation session. I'm not finding it. Let me jump there for you. I didn't want to scroll my lower.
Hello, my lord. I think I've seen it.
Okay.
Yes, it's still at the page 308.
Oh, okay.
Special resolution.
Okay, go ahead.
Special resolution has the meaning assigned to it in paragraph 14 of the 8th schedule.
Okay. So, paragraph 14 of the 8th schedule. So
Yes,
let's
please.
go there and find out. So let's go to the 8th schedule. And we locate paragraph 14.
Paragraph 14 talks about types of resolution.
Okay.
So A, it says, a resolution is an ordinary resolution when it's passed by a simple majority of votes cast by the members of the company who, being entitled so to do, vote in person or where proxies are allowed by proxy at a general meeting.
Okay.
Then B, a resolution is a special resolution when it's passed by not less than 3/4 of the votes cast by the members of the company, who, being entitled so to do, vote in person or where proxies are allowed by proxy at a general meeting, of which notice specifying the intention to propose the resolution as a special resolution has been duly given.
Okay.
Then C, a reference in this act or in the registered constitution of a company, debentures or debentures trust deed to an ordinary or special resolution of a meeting of a class of members, creditors, or debentures holders bears a like meaning to that specified in subparagraph A or B of this paragraph.
All right.
The
Yeah, so,
substitution.
yeah, I think you talk about the types of resolution already, isn't it? The 14. Yeah, so that is good. Yeah, so that is good. Yeah, so we are told that special resolution, certain formalities will have to be followed before it is passed. You have to give a notice of it before the meeting is held. They are going to pass that special resolution. And then when you hold the meeting, you need actually 3/4, that is 75% of members of the company to agree with it before saying it's passed. So if you are able to get that done, I want to change the name, you advertise or you send it together like the notice that you want to change the name of the company from this to that. And then so at the meeting, you will put you to vote. And the vote, as I said, must have a certain majority to pass, 3/4, which is 75%. Now, when that is done, then the registrar will approve it, provided it's not misleading or is undesirable, as we have discussed already. Now, it is also possible that maybe through, yes, Edward, your hand is up. Let's hear you.
Yes, sir, my lord. I want to find out, is this special resolution similar to maybe takeover, i.e. in the case of MTN, you know, they move from space phone to Ariba and then on and on and on. So those takeovers, are they almost the same or are they the same as the special resolution? So meaning if another company is taking over another company, must the resolution, this special resolution be passed to have the name changed, or is there any other law in relation to this? Thank you.
Right, Edward, we have what we call the arrangements, amalgamations, mergers, takeover, what we call the corporate transformations. We discussed that as a separate topic on its own in the second semester. But just for your present interest, should it happen that 2 or 3 companies are merging, oftentimes a new name may be adopted. So they may say, okay, either we register a new company to take over the 3 companies that want to come together, or we do some kind of like combinations. You maintain the name of one of us or something like that. So it all depends. It all depends upon what the combinations are, and there are various routes to achieve that. There are various routes to achieve that. There are various aspects of mergers. You have the vertical, you have the horizontal, and so on. We discuss that as a topic on its own. But special resolution is just a type of decision made in the company, and it's so called because you must give notice that's going to be passed as part of convening the meeting, and that when it is also passed, it must get a certain threshold, 3/4 majority before it will be considered passed. That is why it is so called special. Ordinary resolution, you don't need to give any advance notice, and then you don't need any special majority, just a simple majority. So if you get 50 plus 1 of those present, then it is a pass, and that is what we call ordinary resolution.
Thank you, my lord.
All right. Okay, so let's keep that in mind. So we're making the point that if maybe through inadvertence or anything, at the time that the company was registered, or when you apply to have a new name registered, the registrar approved the name, but maybe he didn't apply his man to it. Now later on, it becomes clear that the name should not have been approved in the first place because it is misleading or undesirable. The company shall change the name with approval of the registrar. And where the registrar so directs, within 6 months, the change will have to be effected. But of course, when the company becomes aware that, oh no, this name or the registrar himself becomes, this name should not have been adopted. So request is made to the registrar within 6 months of they realizing it or he discovering it. Then you make an order to the company that, yes, they have a period of 6 weeks within which they should take steps to change the name. So here, when the name is going to be changed, it will not be like how you pass a special resolution, because here you've been directed to comply. So where the registrar is of the opinion that by reason of a change in the objects of the nature of the business, the name on which the company is registered is misleading, undesirable, the registrar may direct change. So let's say that you set up a company and it's not a requirement that you should state the object of the company. When you say the object, that is the nature of business that you intend to do. It's not mandatory. But where you chose to state it, you said that maybe you are going to do telecommunication business, and you find yourself no longer doing that. You are doing forest products business. And certainly, the name that you have taken, you have chosen when you say you're doing telecommunication business, will no longer be fit for forest product business. So there'll be that kind of mismatch to be misleading. So that would be a good case for the registrar to direct that you change the name to align or to reflect what the company is actually doing. And when the registrar makes the order, it has to be complied with within 6 weeks, unless maybe you decide to appeal it. You make an appeal to the High Court against the direction of the registrar. Yeah, so once the application once it is confirmed that the change is going to take place, depending upon, of course, what the outcome of the court case was, the company will have 6 weeks within which to comply. So if the registrar said, I change the name, you rush to court. Okay, when you go to court, one of two things: either the court will agree with the registrar and say that what the registrar has directed is in order, so you must comply. You have 6 weeks. Or if the court says that what the registrar has said is not right, then that'll be it. I asked you for more examples of lifting the veil. You didn't tell me. So if you look at the 2110, for example, it's another example, isn't it? That where direction has been given by the registrar that you should change the name, and then you don't comply.
Yes.
That will be an instance for officers who were cognizant of the default to actually pay a certain fine, administrative penalty. Again, where there has been a change of the name of the company, a new certificate of incorporation is supposed to be issued. But mind you, the certificate of incorporation bears the name. So if the name of the company has changed, then you need a new certificate to reflect the new name. So that will have to be done. And now there is what we call the company's bulletin. Previously, we didn't have anything like that. We have just said the Gazette, but now under Act 992, they've introduced what we call like the company's bulletin, and the company's bulletin, which has like the equivalent role of the Gazette, is a publication in which matters relating to companies under the regulation of the registrar are published. So the registrars advertise the change of name and the company's bulletin, and also on the websites of the Office of the Registrar of Companies, and in one daily newspaper published in Ghana, and circulating in the district in which the office of the company, which is changing its name, is actually located. So let us keep that in mind. So where a certificate or advertisement is pulled from the company's bulletin, that is regarded as conclusive evidence of the change to which the change of name relates. So let us keep that in mind. But let's also note this, that the mere fact that the company has changed its name shall not affect the rights and obligations of the company. That is very important. Let's suppose that the company has certain cases, right, in court. Some people have sued the company or has sued somebody. And in the course of time, the name of the company is changed. That per se will not affect the legal proceedings by or against the company. And the legal proceedings by or against the company could continue under the old name, as it were. There's nothing wrong with that at all. So it's not the case that you're owning someone as a company, you are sued, and then you quickly go to change of name, thinking that once you change your name, then that will be the end of the matter. No, it doesn't really work like that. So let us take note of that. Then we also have a reservation of name. It is possible to reserve a name before the incorporation is even done. So if you look at section 22, an application for reservation of the name of a company may be sent to the registrar and shall be in a form approved by the registrar. So by reservation here, we are talking about the fact that you are desirous of setting up a company, right? But there's a particular name you want to use, and you want to avoid the situation whereby another person will go and register it before you go and register yours. So the law allows you to get it ready to reserve once you pay the money, and it can be reserved for a period of 2 months. And after the first 2 months, you can go and renew it for another 2 months. But if you look at section 22(3), what it means is that after one renewal, you cannot do again. So like you can reserve it for maximum of 4 months, 2 months in the first instance, and then 2 months in the another instance. So if you are going to register a company and you have a proposed name, but someone has a reserved name, if it's similar to the reserved name, the company registrar will not permit you. Yes, Godfred, Congo.
Yes, my lord. Please, my question relates to the change of name.
Okay.
Let's say, for example, in the registration of the company, I chose a name which is universal in nature. For example, AKG Finance, AKG Company Limited is universal, but I've stated the object of the company to be food processing. But later on, I decide to change to construction company. Will there be a need for me to change the name, saying that it is universal in nature and I can do anything under it? Or
Right. Okay, good. If the name is general and it does not actually suggest that you are doing only a particular thing, then you don't need to change it. So at every point in time is a decision which will have to be made, and this is a factual determination as whether the name that you have, whether it's misleading or not misleading. Yeah, so it will depend upon the circumstances of the particular case. It's not automatic that because you've changed the business, you should change the name. As you rightly said, if your name was a very general name and it does not connote that you're doing any particular business, then once you change, so be it, it will not be necessary. And in any case, if you look at the current dispensation, right? If you look at the current dispensation, especially, you will notice that it's not mandatory for a company to have a nature of business actually disclosed or stated when you are setting up like the company. So I refer you to so like you read section 19 and section 20, for example. Later on, when we are discussing company transaction, we'll come back to it. But under the current law, Previously, stating the nature of business was a very important thing, and because of the doctrine of ultra vires and how straight it was. But there has been a bit of realization of that. So what you have said is possible that you may have like a very general name, so long as nobody has taken it and the registrar does not determine that it is misleading and you are permitted to have it. If you keep changing the business that you are doing, it may not warrant having to change the name again. Yes. So just before we finish discussion of name of a company, we have to add section 125 to section 21 and 22. We've already discussed section 21 and 22, but you must add section 125 as well. And section 125 speaks to publication of the name of the company. And we've already discussed that the fact that the name of the company should properly be written or painted at the registered office, the fact that it should properly be written on the seal of the company, the fact that it should properly be written on the letterheads or business circulars. And again, we have also looked at how the veil may be lifted if mistake is made. And again, if you look at 125.5, 125.5, which ties in with what we've discussed under section 21 already, that if you use the abbreviation, the suffixes, instead of writing them in full, it's sufficient for the purpose and will not be considered to have breached the law, which says that you should properly write the name of the company at the company premises and then on the company trading documents. Any question on the name of the company before we move on?
Hello, my lord.
Yes.
I would like to add, my name is Registrar. I would like to add to what you discussed about what Mr. Konglo said.
Right.
Mr. Konglo was asking about the change of name. Should, in case you have a company that you have multiple tax, is it advisable to change the name to a different one or not? Well, I just want to add a little bit to that.
Right.
We have a lot of Dr. Kwame Chase Unity Group of companies. We have Kesman, they have some names with the companies they have multiple tasks that they perform. So with what you add to it, I just want to say you can maintain the names right and still operate as what you want to do.
Right.
Concerning the multiple tasks being done by the individual himself. Let's say Kesman is doing petroleum. He's also doing different aspects altogether. So mostly when they pick the names, they remain those names, but they have different tasks that they perform. Thank you very much.
Right. Thank you very much. Good. When is your next class? Well, there's no class today.
My lord, we have it at
My lord, our next class, 12 o'clock.
We have lectures today, 12.
Okay. All right, then I will leave you to get ready for campus. So we have